I'd like to introduce our presenter. John Donner is an attorney with the law firm of Roach, Lennon, and Brown. John is also a former managing attorney for the Western New York Small Business Legal Clinic. And he is a past volunteer for SCORE Buffalo Niagara, as well as a regular workshop presenter for our chapter. John earned his law degree at the University of Buffalo and has also degrees in engineering and business. John, I want to thank you for taking time out of your busy schedule to go ahead and present tonight. At this point, the microphone and the controls are yours. Go ahead.
Okay, Ted, thank you very much. Good evening, everybody. Glad to see that took the time out of your busy schedules. We're doing an overview introduction on intellectual property today. Now, depending on what type of business you have, there may be different elements of intellectual property that may or may not apply to your business. So we're going to look at the basic types, and then I also lump in there trade secrets and company confidential information, even though that's kind of a quasi intellectual property. There's no formal registrations. For a lot of businesses, that's going to be some of your core data that you really want to put some controls on. So without further ado, we'll just get into the presentation here. So what I'm going to do is I've got a PowerPoint deck put together, the basic presentation. And then after that, with respect to confidential information, I have an example consultant agreement as well as a data exchange and disclosure agreement, so that you can see the things that I'm talking about in the presentation, what they look like in an actual document. The other thing is I have a supplement on patents, just in response to a couple of questions that Ted got this afternoon and he forwarded to me. So for the ease of jumping back and forth between presentations, we'll go through the PowerPoint deck first. Let's get going here. Okay. Hang on, Ted. There we go. Okay, so first, of course, I'm talking about generalities, and for specific instances for individuals, you should talk to somebody face-to-face about the specific instances with your business. Okay, so let's talk about the purpose of intellectual property. So when you get the intellectual property rights, that kind of grants you a limited monopoly. And so what we're doing here is we're inducing organizations, inventors, authors to create new inventions and works. And so what we do as a result of that is somebody creates an invention, then they have exclusive rights to use that invention for a certain period of time. Same thing when you look at trademarks, copyrights, where it gives the originator rights, that exclusivity. And then when we look at, there are going to be limits that intellectual property law put on this. So if you have, for example, a patent on an invention, typically if it's going to be a utility patent, which is the most common type, you have that patent for 20 years. It's not like you have it forever. So there are some certain limitations on it, but it's that incentive so that as people develop technology, that for a certain period of time, they have those exclusive rights to it, where they can earn some revenue off of that before it becomes public domain information. Competitors can jump in on those particular markets as well. All right, so let's talk about the categories of intellectual property. And so that's why I kind of split up and I talk about quasi-intellectual property, and that trade secrets and company confidential information, it's not like there's a statewide or federal registration, but yet this is documents, processes, things of that nature, which can be fundamental to your ability to raise revenue. And it's, information that's not available to the general public. So we obviously want to put some protections in place to safeguard that information. Then we look at what we'll call the traditional intellectual property components, where we talk about trademarks and service marks, copyrights, and then of course the big one is patents. All right, so can a product or service have multiple forms of intellectual property associated with it? And the answer is yes, of course it can. And so you think about, here I've got, my son's got the latest and greatest. I've got, I think it's an iPhone 12, something along those lines. And so you look at, what would be the IP associated with that? So obviously the mechanism for the data encryption, there's probably a patent for that. These things now have pretty high-tech cameras on them. Those are going to be patented as well. Depending on what the carrier is, you may have a Samsung phone that's marketed as a Verizon phone, something along those lines. So it's going to be marketed as a brand. It could have a registered trademark associated with that. The screen design, the look, the feel, obviously the first one with the smartphones was the iPhone, and there's certain elements of that could be copyrighted. You look at the commercials and you see now Samsung's come out with some of the new ones, and they have features that are exclusive to their phones that you wouldn't get on an iPhone, but there's probably some complementary version on an iPhone. And then of course, the other thing would be in some cases that the phone manufacturer is going to have some kind of licensing on the operating system. You also have situations where if you have clothing, that there could be either trademark or copyright or licensing of images. You think about, is it FanDuel, I think, where you see the commercials where they sell all the official merchandise for the NFL, the NHL, college sports, NASCAR, you name it. They have just about all the sports lined up along with product lines. I know Aaron Andrews has one, the ESPN sports person, and others. So, all kinds of licensing, that kind of thing that's involved, not only with manufacturers, but with sports leagues and everything else. So intellectual property, it's broad-based and it covers all kinds of products and services. All right, so let's talk about, and this is one that most small businesses, so they'll have some interaction with, is trade secrets, or let's call it company confidential information. So what are the characteristics of that? So obviously it's going to be something that it's not general knowledge to the public or readily ascertainable. It has some commercial value because the use of it gives the organization some kind of economic advantage due to its secrecy. So it could be the way you manufacture something. It could be a process for coating different materials. It could be recipes if you're in the food service. It could be matter that, the recipe has standard ingredients, but it's the particular process that you use is what adds the flavor or gives it that uniqueness type of thing. And it's typically going to be guarded by the organization by some kind of reasonable means. So what kind of information classifies as this? So, obviously, if you're in technology, it could be technical specifications, it could be designs, especially if you're in the commercial marketplace. It could be formulas, it could be manufacturing techniques, it could be software. And across the board with businesses, your general business information. So it could be financial data, and that could be anything from, your cost rates. So it could be, what are your, if you're providing services, do you have hourly rates? Are they departmental rates? So you're not just looking at raw labor costs, but it might be your indirect rates, your overheads, your G&As, that kind of thing, how costs are calculated. Market research could be customer or vendor lists. It could be unannounced business negotiations. You're looking to merge with another company to expand your market, things like that, that it has some value in the fact that it's not disclosed. And then when I talk about the know-how, knowledge on how to do something better, faster, cheaper, and that if you're a manufacturer, it could be up in the technical information under manufacturing techniques. It could be just the way that you process information, you service clients. It could be something as simple as, you go to Ted's Hot Dogs and how do they handle a big volume? It's the way they have their kitchen set up, the way they have the ordering techniques, everything else, the way that they order the provisions, things of that nature, that maybe there's attributes that are unique that competitors don't do. Okay, so now when I talk about points of risk, talking about events where there could be some exposure to your trade secrets or your company confidential information. So obviously, I spent 25 years in aerospace and defense, and then 12 years working for a global environmental firm. And a lot of times we might be the prime government contractor, other times we might be a subcontractor, a team sub. So a lot of times you may have formal joint ventures where you've actually formed an organization, or it could just be a teaming agreement for a specific contract. And so a lot of times when you put a proposal together, you're going to have all kinds of proprietary, labor rates, overhead rates, that the cost information, maybe technical specifications, that kind of thing, that you're submitting a proposal to the government. That information has to be in there. Well, to do that, you're providing it to another party. So that's, a necessary evil. That information has to get to them. But then how do you protect it that nobody else uses it for other than the stated purpose? Another issue can be when you bring in independent contractors. They could be consultants. They could be a marketing representative. They could be temporary technical help, whatever. You bring in an outside party, you're going to have to expose them to some of the sensitive data. So you have to make sure that you define what the limitations are, what the rights are, who maintains the ownership, that kind of thing. And then, of course, another thing that you have to look at is, your employees, depending on what they do for the organization, could have exposure or intimately use this information on a daily basis. So then if these employees, leave the organization, not only are you losing that institutional knowledge, but you want to make sure that you maintain your company confidential information. Okay, so how do we do that? So one of the things that we can do is we only divulge the information to people on an as needed to know basis. A lot of times, like when I was working for government contractors, in terms of overhead rates, labor rates, that kind of thing, typically it was limited to the marketing department, the pricing, the proposal departments, that kind of thing. Plus, people in the accounting department, if they're involved in corporate compliance, that kind of thing, but not necessarily the person working out in the field or an engineer needs to know that information. So you kind of control it that way. You can use either a confidentiality agreement, a non-disclosure agreement to look at the rights. And so it talks about, it could be a one-way agreement. It could be an agreement that works both ways. And it'll talk about, whether or not you have to mark information. Once you're done with the project, do they destroy the information? Do they turn it back to you? What rules and regulations take place? And if somebody later on would use that information outside of the organization to their advantage, then you could file a breach of claim for violation of these agreements. Again, keep the information out of the public view. So it's not going to be on your website. it's not even going to be exposed to all your employees. You know, you talk about placing information in a restricted area or grant restricted access. So, I mean, that can be a matter of, I've been in situations where, you know, I had government secret clearance for 18 years. And then there was a very select number of individuals that actually had top secret clearance. And to have top secret information, it was always maintained, and they'd call it a SCIF. It would be a dedicated area in the factory where only people that had top secret clearance had access on their badges where they could actually badge into that part of the facility type of thing. So that's one way you can do it. Another way too is that, you know, passwords, or you can control computer access. So when you look at, you know, nowadays in larger organizations, you have enterprise-wide software solutions that integrate manufacturing, accounting, marketing, all of the different functions all on one software platform. Well, depending what your function is in the organization, you only have access to certain parts of the data, certain parts of the operating system, that kind of thing, which is handled by the network administrator. So you have different levels of authority to go into the system itself. All right, so then after we do the presentation, I have a sample non-disclosure agreement. This particular one, I call it a data exchange and disclosure agreement. And then I also have a markup of a consultant agreement. So it gives you an idea. We'll go through those documents and you'll see some of the verbiage, some of the provisions we put in there to protect the interest, how we allow people to have access to it, how we retain the information later on, that kind of thing. All right, so now we're going to start digging into the traditional intellectual property. So we talk about trademarks, and really service marks is a derivative of that. So what it is, it's a distinctive mark. It could be a symbol, it could be an emblem used by a business to identify and distinguish its goods from those of others. So you think about, it could be the Ford Motor Company blue oval, Chevy's got the bow tie, Nike's got the swoosh, Apple has the apple with the bite out of it, those kind of things where you see that symbol and you know right off the bat with the company's identified with it. So it enables the consumer to identify a product and its source, and there's state and federal sources for registering trademarks. All right, service marks are similar, but then they're going to be tied into a service rather than a product. And in some cases, it may be the same mark if it's a corporate logo. But yeah, I mean, there can be some distinguishing factors depending on the nature of the mark, what it's used for. And we talk about collective marks. So you could have, you know, these are like memberships and associations. So somebody talks about the ABA, the American Bar Association, or the New York State Bar Association, or American Medical Association, where in some cases, somebody may have letters after their name and it's tied in with some kind of distinguished membership, an association membership type of thing. The other thing too is that you'll see certification marks. And so those are used by third parties to guarantee that certified goods meet certification criteria. So, I mean, you could have, you know, you buy an extension cord over at Value or at Home Depot, and it's got the Underwriters Laboratory, the UL tag on the cord. Or you've got, you know, businesses back around the year 2000, when we started going with the international standards. And first of all, it was like the ISO standards, and it was ISO, I think 9001, and there were series there, and there's been several series since. And you see some companies, they'd actually have, ISO 9001 compliant on a flag flying on their flagpole, that kind of thing. So you have certification marks, but the traditional ones really are the trademark and the service mark. All right, so elements of the trademark. So it's got this distinctiveness. So you identify the origin of the goods or services, and it must be inherent. It's not something that you look at and you wonder what's going on type of thing. It has that recognition in the marketplace. Now, in some cases, it may be narrower than in others because it may be something that's not a consumer good. Maybe it's something that's known in different industries, something along those lines. But there's some kind of inherent recognition with that mark and with the name of the organization. And then use. The trademark has to be used or have a demonstrated intention to use. Okay, so registration. So you can go to the U.S. Patent and Trademark Office, USPTO. Go through a trademark registration process. So what's that do? It gives you evidence of a trademark's validity. It provides, proof of the registrant's ownership, provides exclusive right to use the mark in commerce. And then, situations where, now we see in the last 15 years with online sales, you can be operating a business off your dining room table, and you can be doing national, if not global sales. And so with the internet, you could have a name and establish a brand recognition where when you were just a local merchant, that really didn't come into play. So in that case, it may make sense to register your trademark, your name type of thing. All right. And then, one of the things that I've got in the references, I've got the website for the test, which is the USPTO online search for trademarks and copyrights. And you can do a basic word search where you can put in a name and it'll show all the affiliated trademarks and service marks. And what's interesting, you'll see that a lot of times half of the listings are abandoned because either the organization's gone out of business or it turned out it really wasn't that valuable an asset, so they just let it go. Or it becomes generic. That can be the other case. All right. So now we're going to go into copyrights. And these are more when you think about like the arts, and the exceptions could be computer software, although that's now shifting towards patents, and architecture. So it can be design, it could be a work of art, something like that. Years ago, you had to go through the formal registration process, but then about 45, 48 years ago, the Copyright Act of 1976 provides that copyright attaches to the work upon creation. So it takes a little bit of the energy off of the formal registration process that was once there. But it's important to note that if this is something you really want to protect, that you should probably go through the formality, the publication, the registration, the notice, that kind of thing. Because when you go through the formal registration process, then that gives you all the rights and remedies and means of enforcing if there's any kind of copyright infringement. All right, so what are the exclusive rights for a copyright holder under the Copyright Act? So one of the things is that the originator has the right to reproduction. So it prevents others from making unauthorized copies. And again, when I say unauthorized copies, the originator may give permission to someone to make copies. We talk about the right to derivative works. So unauthorized translations, dramatizations, motion picture adaptations, you talk about, books that are turned into movies and they got to go to the author and get the rights, that kind of thing. Or the same thing where a play gets turned into a movie, that kind of thing, where there is, for the adaptation, there has to be permission granted by the originator. Now, what isn't under that is parodies. And so it's kind of what constitutes a parody or not, is it obvious or not? It's one of the issues. The rights to distribution. So it prevents others from selling, renting, leasing, or lending the work, type of thing. We talk about the first sale doctrine. So it says once a copyrighted article is sold without restriction. So the distribution rights no longer prevent further distribution. So if somebody, they decide they're going to make additional copies of their artwork, and then they send out and they don't put any restrictions on it, then it's almost like public domain, and then you don't no longer have control over it. And we talk about the right to performance. So it, obviously, usually you can see it's things like nonprofit groups, religious services, charity, fundraisers. So if somebody's publicly performing something in public, that doesn't fall under, there's no copyright, rights under that. And then the right to display. So it prevents others from publicly displaying the copyrighted work, with the exception of a public display of the work at the place it is located, type of thing. So, somebody buys an original artwork and it's donated to a museum. There it is in a public place. Or the bank buys an original original painting to hang in the lobby of their in the bank. There it is. It's going to be in the public for viewing, that kind of thing. So that they have the right to display it because that's part of the purpose of why they bought it. All right, enforcing copyrights. And it's kind of tough to do. It occurs when they're exercising activities otherwise reserved for the owner. And so, first of all, from an infringement standpoint, you got to prove there's a valid copyright and the mark must be registered to file suit. So that kind of goes into where we talked about, the Copyright Act of 1976 eliminates some of the need to go through the formal registration process. Well, if you haven't done that, now you can't file an infringement suit. Then you got to prove copy. So it could be direct or circumstantial evidence. And then you look at this to indirectly prove copying. You have to show that the infringer had access to the protected work and that the accused work is substantially similar to the protected work. So again, can be difficult in some situations. And then we talk about the defenses to infringement. And it's kind of like we saw on the previous slide where we talk about, performance or display for educational purposes, course of worship, free public concerts, charitable fundraisers, that kind of thing. Software and that copies for personal use and software backups. And then, of course, we talk about fair use, or in the case where there's something looks pretty close, but it was independently created, type of thing. Not a copy, but independently created. All right. So now we're going to talk about patents. This is kind of like the holy grail, where we talk about, an invention, and it could be typically going to be some kind of product. And so think about, for example, a drug company that they develop a new drug, they go through all the trials and the testing, the different formulations on it, adjusting it to, they find they have side effects, that kind of thing. And then once everything's there and approved by the FDA, they have this patent which allows them to be the sole supplier of that particular drug for a certain period of time until the patent runs out. And so, you say, well, is that fair to the consumer because it costs that much more? But then what you're also doing is that if they can't bill at that elevated price, the hundreds of millions of dollars or more that they're putting into developing these drugs, they have to rely on that increased price and that increased revenue to pay for the cost of research and development type of thing. So what we have here, we talk again, it's kind of a limited monopoly that gives you the right to exclude others from making, using, selling, importing, or offering that same invention, that same product for sale. And again, it's limited from a standpoint that there's a time period that you're limited to. So what do we have? What are, again, characteristics of patents? What are the limitations in terms of subject matter that can be patented? So you have any process, product, or design that meets the criterion for patentability. And so what you would look at is you would look at the guidelines that the USPTO puts in place, look at the application, that kind of thing, to see whether it applies or not. So then we look at is we talk about, laws of nature, naturally occurring phenomenon. Abstract ideas are not patentable. An idea is not patentable. It has to be something that can be reduced to practice and demonstrated. All right. Now, one of the other things is that there's value to a patent in terms of a property interest, especially, depending on how many years is left on the patent, whether that patent generates sales or not, it's going to have a certain market value, and that can be used in collateral for secured transactions. So that can be a very valuable piece of collateral. Again, a valuable asset if you're selling an organization. Patents and intellectual property are a big part of that. It could be the way that that particular manufacturer or organization controls a certain percentage of the marketplace, that kind of thing, a certain market sector. So again, there's some inherent value to having patents as property interest. All right, so let's talk about types of patents. So we talk about the common one is the utility patent, and that covers processes, it covers products, and in general, it expires 20 years from the date the patent application is submitted. Design patents, in contrast, are non-functional. So they're more like ornamental designs, that kind of thing. And in that case, they expire 14 years from the date the patent is granted. They have one for plant patents, which covers plants, flowers, vegetables, that kind of thing. Hasn't had a lot of action. What will be interesting in the near future as the whole cannabis market comes into play, that we'll have to see if people are coming with hybrid versions of cannabis and CBD oils and things like that, how that's handled from an intellectual property standpoint. And again, that market's still in its infancy. And then now they're getting to the point where now, we saw under copyrights software, now they're looking at patents in software as well. But, you have to be careful there. It's going to be pretty stringent on what would qualify as patentable software. All right, so we talk about the utility requirement. So meeting the utility requirements. So the invention has to be capable of a practical application or provide some kind of commercial benefit. It has to be operable and it has to be reduced to practice. And so what we're talking about there is that, again, we talk about invention with a use versus an idea or a concept, which isn't patentable. Okay, so now I've got some related websites. So we've got the ones that we would look at here specifically is if you go to the third one there, the trademark electronic search system, that allows you to go in and actually search the US Patent and Trademark Office website in terms of you can type in a term or series of terms to look at what is there in terms of trademarks and service marks. Now, one thing with trademarks is that it's not just the name, but it's going to be a very limited market sector. So, for example, you look at Ford or Apple, to cover the entire market, they may have 40 or 50 individual trademarks for that same design because it's going to be individual market sectors. So you have to look at, there can be more than one business could have a name trademarked if they're in different industries. So if you just file a trademark in your particular market sector, you don't have that trademark for that term, for that image across the board. I mean, with the images, they're going to be more unique. Where you get into the situation is more if you're trying to reserve a name, have the ownership of a particular name. It's where your real protection is going to be if it's in the same market sector. And so I'll give you an example. I worked with a client a few years ago. She has a sewing center. And so they sell, home and commercial sewing machines. They sell materials, they sell supplies, they run classes, that kind of thing. She's been in business for, at this point in time, probably 30 years. Years ago, your sales were all in the shop. Maybe there'd be a small amount of mail order sales to regular clients, that kind of thing, or commercial embroiderers or something along those lines. But then all of a sudden, 15 years ago, all of a sudden you have online sales. And so there was another, let's call it John's Sewing Center. And she has 2 locations. Well, there's another, in another state, there's another John's Sewing Center that's been in business for about 10 years less. Same marketplace. Well, what happened was about 5 years ago, the other organization trademarked the name because now all of a sudden there can be an overlap when you're selling similar supplies online because of the global marketplace. So what happens is that she gets a cease and desist letter. And even though she was in business first, the fact that the other firm trademarked the name, now all of a sudden she has to change her name, to a certain extent. And the fact that, she had the public domain name for the .com and things like that doesn't come into play. It's not who's first in business, it's who's first to file type of thing. So that could be a situation like that. I had a client a couple of years ago. She's making mixers for alcoholic drinks, but she's just selling the mixers. So she's in the non-alcoholic market. And her name was like Bloody Mary Mafia or something like that. And she trademarked the name. And then there was a local bar that came out with a drink that had a very similar name. And of course, they're trying to market it. And so they turned around and they sent my former client a cease and desist letter, say you can't use that name anymore. And of course, the answer to that is not only no, but hell no, because they're the ones that we can send the cease and desist order to, because we have a trademark on that name for what she's using it for. So she has the exclusive rights to that name for the non-alcoholic mixer segment of the market. So it comes into play like that. For a lot of businesses, it's not an issue. If you're a big manufacturer or something like that, you're typically not going to be doing a lot of online sales type of thing. If you own a restaurant or a store where it's all going to be exclusively, walk-in traffic, that kind of thing. Again, a lot of times you may not be able to trademark the name because every town probably has a Main Street cafe or something along those lines. So you have to look at those variables as well. Talk about cost. When you talk about trademarks, service marks, that kind of thing, you're talking probably $1,500, $2,000, because there's a lot of, attorneys not just do the filing, but they do some background searches, things of that nature. So that's, why it costs that. You can try doing it yourself. You may not have access to all the databases. So then if you spend, I think the filing fee itself is like, there used to be like $275 or something like that. Well, all of a sudden, if it fails, then you may eat the cost of the filing fee because they did go through the process. It turns out you just can't have the name. And that process typically nowadays takes about a year or so, that kind of thing. All right, let's go next one here. Okay, so I've just got my background information. So we're going to get, yep.
Yeah, John,
Sure.
we have some really good questions that are in the chat right now.
Okay.
The first one talks about how does intellectual property apply to recording artists? And as a matter of fact, a couple of other chat questions also kind of probe that same area. Can you talk about our coverage for intellectual property for artistic types, recording artists?
Recording artists per se, I can't, but I know, for example, if you look at photographers, you would think that the client would own the intellectual property rights, but it's actually the photographer that retains the rights. And so then they can still use the images like on their websites, things like that. But what they do is, they make the copies and they license the clients to use the photos because they're not going to use them commercially. So, they may make copies, down the road for relatives or something like that. They obviously want to sell as many copies as they can, but the actual ownership of the negatives, the images themselves, belong to the photographer. And you think it's maybe a little counterintuitive because you think of the wedding photographer as being a work for hire type of thing. And so therefore the bride and groom as the employer would have the intellectual property rights, but that's not the case there. So you have that with that. You can have that a lot of times with graphic designers. Somebody designs a logo, things like that. And again, that can vary because most of the time it's also going to be spelled out in the contract that you're signing. So I'm kind of, yeah.
Yeah, John, did you mention about how long a trademark will be? Well, the question is how long before a trademark falls off? How long is a trademark good for?
I believe it's a biannual renewal. And so if you don't renew it, you can abandon it. You could write in, you could abandon it. If you don't pay the renewal fee, you'll get to a certain point, X amount of days past the due date, then you no longer have rights to it. And that kind of holds true with any intellectual property filings. When those rights are granted, for example, with patents, there's a renewal, I think it's like for the 20 years, there's a renewal, I think it's after like 6, 12, and 18 or something like that, periodically, or every 4 years or 5 years, where there's a renewal. And I mean, it's not like it's a big deal. It's not like a complete application process or anything. I mean, it's kind of like the biannual statement for your LLC or your corporation type of thing with the Department of State. It's just kind of a registration update, or, for me, like a professional license, I've got the biannual registration where I have to pay the fee, and did I do my 24 hours of CLE and things like that. So there is a renewal type of thing. I think copyrights and trademarks are a 2-year period.
Mhm. Well, we can address that question when we send out the PDF copy of the slides and the link to the recording. So
All right. So
I'll put that into the information sent out to the attendees.
okay, so I'm going to hit the
there-
stop share, and I'm going to pull up another document. Are there
Well,
other?
John,
Yeah.
yeah, there are a number of other questions which
Okay.
you might want to tackle before you get to
All
those
right.
documents.
So let's talk about that then.
Okay, well, Kathy has a question here about, and they're trademark questions. What's the difference between the R with the circle, registered trademark, and the TM? Does a business owner need to work with an attorney to apply for registration for a trademark, a business name and logo? How much does it cost to get a trademark? So there it is, the cost again.
Yeah, and we're talking like $1,500 to $2,000. I mean, one of the things is that the attorney may have access to databases and that to perform advanced searches that somebody in the general public can't. The filing fee itself, I think for trademarks and service marks, it's about, I think it's $275. That's, I don't.
Did you get the first part of that? The first part of the question was about the difference between the R with the circle, registered trademark, and the TM.
I don't know that offhand.
Okay, well, that's something else that we can address in.
Right. We can look at that later. Because the thing,
Okay.
it's not as much with copyrights and trademarks, but to address patents, you have to be a licensed patent attorney. And they're fairly few and far between. If you look at in the United States, there's somewhere around 1.1 million attorneys, somewhere between 1 million and 1.1 million. And there's about 32,000 licensed patent attorneys. And I think that also includes what they call patent examiners. And what that would be is that's somebody that's licensed by the Patent and Trademark Office to handle patents, but they're not a licensed attorney. And usually that's a temporary type of thing. My son-in-law's younger brother is a patent attorney in Boston. And he went to law school for 4 years instead of 3. And what he did was in that 4th year, he picked up his master's in engineering as well. And he took the patent bar exam. It's a separate exam. And he passed that before he actually took the bar. So that 1 year before he was an attorney, he was a licensed patent examiner. But in terms of patents, you have to be licensed to practice in that area, either as a patent examiner or a licensed patent attorney. you don't have to do copyrights, trademarks, that kind of thing. And Chris Brown, our younger partner, does most of that work here. And again, he's not a licensed patent attorney, so he can't do patents.
Okay, there's a question, and how would intellectual property come into play if you figured out a way to improve a product that already exists? For example, if I use a product and I figured out a way to add an additional safety feature, or a cooking product and introduced a new ingredient that actually that potentially improves the product, how would intellectual property come into play with situations like that?
Well, that's kind of the gray area, and that what differentiates it from the other product, what makes it unique enough. Because some of that could be technique, or it tastes a little different. And when you get into patents, it has to be unique enough. And I've got, when we go through the overview on the patent process, that may kind of clarify that a little bit. And again, you know, it has to be something put into practice, can't be a concept type of thing. So, you know, there are incremental improvements, but that doesn't necessarily make enough of a change. Now, what you can do, well, when I go through the handout on patents, I talk a little bit about the application process and the different steps in it, and how we would kind of explain and differentiate those things.
Okay. Look, you want to try one more before we
Sure.
go to the?
Sure.
Okay. And this one comes from Kathy. If we create a written work but do not officially register it for copyright protection, can we still label the document as copyright 2023? And she quotes a 1976 act.
Right.
Or is that notation only for work that is officially registered?
Well, I think what I kind of covered, we talked about that now the Copyright Act of 1976, which is what she's referring to, covers a lot of that. The problem is that if you find an instant of infringement, that the only way that if you take them to court, if it's not registered, that makes it difficult to take legal action against them. I mean, you may, because the registration kind of is a proof, you know, if it's not registered, you know, depending on the work, you could have something pretty close that somebody could claim they independently developed. Because I mean, that you find a lot of times, and again, depending on what the creative work is itself, you can have, you know, paintings of the same building, and they can look somewhat similar, but it's going to be the artist perception on it and those differences, but they're both original works. You can have software that takes the same inputs and gives the same outputs, could be independently developed. The coding internally may be different, but to the user, it's going to look identical. But then again, those are independently developed, separate. It's not infringement type of thing. So it really kind of depends. Yeah, with the Copyright Act of 1976, you don't have to go through that process. But if you're not doing that, it kind of limits what your legal remedies are.
Okay. There are a few more questions which we can get to, but do you want to go to the patent?
Well, I'm going to do a couple of things. So first, I'm going to pull up a couple of agreements that talk about protecting company confidential information. And the reason I want to bring that up is that a lot of people, they may not have that traditional intellectual property. It doesn't impact them, but they certainly have company confidential or proprietary information that they want to protect. And then after that, I'll shift into the patent quick. Okay, so let me just go into the stop share. We'll go into, let me see. Oh, hang on a minute. Okay. Okay. Share screen. Okay, Ted, can you see my
Yes,
screen there? Okay. So here I've got a data exchange and disclosure agreement. And so think of this is a different version of a non-disclosure agreement. You can see at the bottom of the first page when we scroll down there, it's dated March 8th of 2002. So, I mean, you're talking 20 years ago. So it's the same basics, but, you know, things could be updated a little bit. So what we're talking about here is this could be a situation where, let's say, you're doing a joint venture, a proposal, something like that, where one organization is going to give company confidential or proprietary information to another party. So how do you protect that? So, you know, we see this is a two-way agreement. So you see in the first provision, we talk about we're agreeing to protect trade secrets and information and data, proprietary or confidential nature. And then we talk about that it's going to be identified at time of disclosure. It's going to be confirmed in writing that, you know, you're going to maintain the information using the same degree of care that you would for your own internal proprietary information. Then we talk about in the second provision, it talks about that, you know, the use is only going to be for the furtherance of the stated purpose of this agreement. So, you know, we look at the intro, it says provide an exchange of information on, and it could be, you know, for providing a proposal on such and such program or something along those lines, or it's going to be detailing what that's for. So you can use that information with respect to that subject matter, but not beyond that. Then we go into and say where all of a sudden in paragraph 3, where the restrictions on disclosure and use do not apply. So that would be information that is available to the public generally at the time of disclosure, becomes available to the public other than through the part of the recipient party. It becomes public knowledge because somebody else screwed up or something like that, but it had nothing to do with the recipient party's action. Part of information that's already known to the recipient before they receive it. So again, that has some kind of public knowledge tied to it. It says information obtained at any time lawfully from a third party under circumstances permitted. We talk about information which was disclosed with prior written consent to the disclosing party, information that was independently developed by the recipient party. And then it says that we look at information that was inadvertently disclosed. Again, as long as you're using that same degree of care. But once you discover this breach, you know, and be a minor breach, that now the recipient party is going to take the measures to prevent any further disclosure of that information. You know, typically you see that, like I have in G, you're going to have an expiration period on it, or it could be, you know, a year after the conclusion of the program, or depending on the product or service, you know, you could just ask for a return of it. So then we talk about, you know, here, again, I'm looking at it from a government contracting standpoint. So we say we have under paragraph 4 at the bottom of the page, the right to disclose any trade secrets or confidential or proprietary information or data furnished to the government for evaluation purposes in connection with a request for proposal or contract. And it says, provided it's identified as data provided by the company and it's got the appropriate restrictive legends. So, again, if we're providing, if I'm working for somebody that's going to be a team sub, and I'm putting certain design documents in there, or labor rate details, things like that, that's proprietary in nature. And the purpose of it is for the proposal. And then that government agency is going to evaluate the reasonableness of the rates and everything, not just to the prime contractor, but of the subs as well. Then the recipient party is going to forward that information to the government as well for evaluation in the overall proposal evaluation. Then we kind of put an effective period for the exchange of the information. We pop in 6, where we would have kind of a point of contact for each party, because obviously that makes controlling the flow of information much easier if you have a central point of contact. It's when you start giving it to various people that would look at it from various perspectives that all of a sudden the wheels can come off pretty quickly. And then it's like we talk about just kind of the basics, where we said that there's no right or other additional rights are offered or granted. Neither party assumes kind of a limited liability or indemnification that assumes any liability for damage arising out of reliance on the disclosed information. So, they don't win the proposal, they give the data back. It's not the fault of the prime that they didn't win the contract, that kind of thing. Again, in this particular case, we say that the non-disclosure agreement doesn't create or give effect to a joint venture, pooling arrangement, partnership, whatever. Usually this agreement, if that's the case, would be a supplement to that joint venture or whatever. But the non-disclosure agreement in itself doesn't infer that a joint venture or some kind of contractual arrangement takes place as a result of that. And then we would just have the respective authorized parties then would sign the agreement. So fairly straightforward, where it has a period of performance, it gives the purpose for the disclosure, it has the limitations, the markings, that kind of thing, and then also the exceptions of when it wouldn't be, the conditions under what it wouldn't be considered proprietary data. Again, a lot of it because it's available in the public domain, that kind of thing. Then we look at a consultant agreement. And again, this was back in my days in aerospace and defense, and back in the 2000 timeframe, there were a lot of additional regulations, especially with results to, procurement integrity, Foreign Corruption Act, that kind of thing. So there's additional provisions in here that wouldn't apply in a commercial application that did in this particular one. So we look at the consultant agreement, where we talk about here up in the top, where we talk about the parties and related to what the general services would be. Then we look in here, the services provided, and this could be a scope of services that's attached. It could be general, where we're going to provide marketing services for, with the U.S. Air Force on the following programs or something along those lines. We look at the term of the agreement here. We've got it set up as a 1 year. We talk about the compensation. In some cases, they may get a fixed rate. It could be hourly, weekly, daily, monthly, whatever. It could be commission-based, that kind of thing. If it were commission-based, then we would talk about, when it's going to paid, what constitutes earning a commission, future commissions, earned but not yet received commissions, entitlement once the agreement is terminated, other commissions may be due. Talks about, again, taxpayer ID or the social security number, reimbursement for expenses, invoicing. Then we look at the ones I've got highlighted where we talk about the relationship of the parties, that again, this is an independent contractor. They're not going to be treated as an employee. They're not entitled to any benefits or any of the other things that employees get. We talk about the ownership, the rights ownership, and that, similar to an employee, that any of the confidential or proprietary information developed by or disclosed by the consultant as part of their duties is going to be the property of the owner. And then we talk about here that in 6, protection of information and proprietary disclosure. Again, we talk about there's the opportunity that we would have to disclose confidential and proprietary information related to them providing those services. And so then we just talk about, how we're handling it, protection of it, duty of care, that kind of thing. Then when we talk about business policies, depending, this may not apply if you have a very small firm, but you may have business policies that, you would sign up to, that kind of thing. Then we talk about, this gets into the government where we talk about the Department of Interior and, limited use of funds. And of course, if you're marketing with the federal government or internationally, where you're talking about influencing certain federal contracting, officials and transactions, that kind of thing, Procurement Integrity Act, which wouldn't apply, other government policies type of thing that we go through. Then we get into the conflict of interest, that, you're going to avoid any conflicts of interest with third parties, and that if any occur, you immediately notify the company. And of course, the other thing that we put in here, especially if they're doing marketing for us, is that we want a written list of the other organizations that he represents as well. So we can look at that to see, are there any direct competitors, that kind of thing, which could create a conflict of interest as well. Then you go through the normal verbiage that you have in agreements where we talk about governing law, notice, waiver, assignment, that kind of stuff. And then we talk about, having the authorized representative of each organization sign. So you can see that here, again, even with a consultant agreement, and similarly, you may have, if your employees have to sign an employee agreement, where you have very brief things where you talk about, disclosure of information that you need to know, how you protect it. It's owned by the company. You may have to turn it back in or otherwise destroy it when you leave the company, type of thing. All right. Now let's go to patents. All right. So I apologize. Let me get it a little bit bigger here. How's that, Ted? Can you see it okay?
Yeah, it's coming in really well, John.
Okay. So we talk about an overview of the process. So we talk about patent defined, and like we talked about in the PowerPoint, that, what is a patent? And it's really a property right that's issued by the government to inventors that prohibits others from making or using an invention for a limited period of time. And then when you have a patent, if somebody steals the invention or uses it, has unauthorized use of it, then the patent gives the inventor the right to sue the infringing party. So when we talk about patents, the primary one is the utility patent, which protects inventions that have a specific purpose. The design patent, which is non-functional, as opposed to utility, it's more like unique shape, aesthetic qualities, that kind of thing. Then we talk basically about the plant patent, which probably in the past, other than like arborists and things like that, hasn't seen an awful lot of action. In the future with cannabis and other things like that, may see growth in that area. And then finally, software patents where you're going to protect software. And again, limitations on that. So we talk about reasons to file a patent. So it's going to gain recognition, protect intellectual property more often than not, because you want to profit from the invention type of thing. So reasons not to patent. All right, your invention is not patentable. So it could be more of a concept. It's not reduced to practice. It could be impractical. And then we talk about, the invention might not qualify for a patent. So it's not fully developed. You can't patent an idea, or somebody already holds a patent for the same invention. So, I mean, for the one question we had where, you're kind of fine tuning and improving something, we'll talk about that in a minute when we talk about the patent application, but that could be a gray area. In some cases, you may get a patent approved on that. Other cases, maybe not, but we'll take a look at that in a minute. So one of the questions that you emailed to me earlier today, I was talking about a provisional patent. Well, there really is no such thing as a provisional patent. What a provisional patent is, it's a provisional filing. So what it is, it's not a patent per se, but it's really like a 12-month place card for the patent application. So, like we talked about the woman with the sewing center, even though she had been in business longer, the other organization had filed the trademark and then issued a cease and desist order. It's the same thing. And, you see famously, I think it was Edison and somebody else, that maybe Tesla, that, somebody knew somebody at the post office and the patents were going in at basically the same time. And Edison was able to get in there first, I think was the way it went. And it's the US Patent and Trademark Office. They base it on first to file, not first to invent. So that is maybe one of the reasons why you would want to do a provisional patent. So what that does is it's good for 12 months. You can't extend it. And while we talk about the first to file, what happens is then, let's say in most cases, it's going to be a utility patent. So what happens is within that 12 months, you file the more detailed utility patent. Well, from the first to file standpoint, they give you credit for the filing date of the provisional, as long as there aren't any material changes that would invalidate the provisional filing. So that kind of gives you that jump start, kind of reserve your place in line type of thing. So like I say here, it allows time to fine tune the invention and prepare it for the market. So what you have here is the application. It's a much simpler application than, for example, the utility patent, the software patent, the plant patent, whatever. The final patent is that it has a description of the invention, but it's not the same level of detail that you would have on the final patent application. You want it to be accurate, but not too specific, because if your final application covers additions and changes that weren't addressed in the provisional patent application, then you can't use that filing date of the provisional application because you're filing something different. And again, what this allows, it's not a patent per se. What it is, if you have something and you want to get the product out to market, that kind of thing, and this would be in a situation where maybe you're the manufacturer as well, then what you can do is you can run it to the market and you can do some minor refinements on it and that kind of thing. And that would be, the term would be patent pending. It's not going to have a patent number. It would just say patent pending. And that kind of goes in with that provisional filing. But the thing with a provisional is that the approval of the provisional is going to be based on the application being properly completed. So it has a significant amount of detail, all the questions are answered, that kind of thing. The Patent and Trademark Office isn't going to do any kind of search of the invention or the attributes of the invention or anything else tied with the provisional application that they will on the final application. So there is no like technical competency or that related to the provisional. It's just a matter of correctly filing the application. And again, it's good for 12 months. If you don't have the formal or permanent application, whatever you want to call it, in within that 12-month period, there is no 12-month extension to the 12-month period. It would just expire, and then the patent that you file for the invention is going to be based on the filing date of that particular application. And again, one of the things they focus on is before there's a public disclosure of the invention, you must apply for the patent, because then it's public information after that. So you don't want to screw yourself on that. Okay, so now we talk about the steps to getting a patent. So, the first thing you're going to do is you're going to work on the invention and you're going to document the entire process. So, because you want to put that, it's kind of like the paperwork for your small business. The more you document, the better, type of thing, because it gives you not only the support information if there's some kind of audit, but down the road, you're applying for a loan or a certification or something like that. Some of this information might be part of the application process. It's so much easier if you already have it prepared, type of thing. So you're going to work on the invention. You're going to document the process. You're going to confirm you have an invention. So what makes it unique? Is there a use in the market? Have you reduced it to a usable form, type of thing? It's not just an idea. You've boiled it down beyond that. Then the other thing is that you look at, okay, you've created something, but now is it commercially viable? If it's something that's so obscure, you may very well not get a patent on it. I'd say hire a patent attorney, because there are going to be all kinds of searches involved. They know the process. They may have inside connections, because like I said, there's 30, 32,000, whatever. It's such a limited amount of people that they may have connections at the U.S. Patent and Trademark Office. They filed a number of these. They know where the hiccups are, that kind of thing. In the long run, it can make it much easier for you, that kind of thing. Submit the provisional patent application. After that, you're going to submit the patent application itself. And then I say the follow-up communications with the U.S. Patent and Trademark Office. They get somewhere in the range of 500,000 patent applications a year. So it's going to sit for a while. And then when it gets rejected, because it most likely will for something, that when they send that information, you want to make sure that you respond to any questions or provide the clarifications in a timely basis, so it doesn't go immediately back down to the bottom of the pile again. Something that I want to note, that if you have your own business, it's not an issue. But if you work for a company, the rights to the invention might lie with the organization and not with the individual as the inventor. So, for example, when I worked for the aerospace company, we had 7 or 8 patents, not a lot. And individual engineers were named as the inventor, but the right holder was the organization. So that doesn't mean that an engineer working for a company can't form a patent, can't file a patent on their own, but you have to be very careful with the documentation. So for example, if somebody was an electrical engineer and maybe they filed a couple patents on behalf of the company where they're recognized, their name's on the patent along with the company, but the intellectual property rights lie with the company. But let's say this person, as a hobby, they work on cars and they came up with a new design for an intake manifold or something like that, that had nothing to do with their job. And they can demonstrate that, you know, they developed this idea on their own time. It's not related to anything with their job or anything like that. Then there's an opportunity that you could file that patent and you're entitled to the rights on it yourself. But ordinarily, if you work for a company that, you know, is part of your job, if you come up with something that's patented, yeah, your name will be on the patent. And so that's nice on your resume and recognition and things like that. You may get a bonus, but in terms of the intellectual property rights, it's going to reside with the organization, not with the inventor themselves. Okay, so now let's talk about the components of the patent application, because this kind of flushes some of this out. So the first thing we're going to do is you're going to have like an introductory executive summary or abstract, where it's going to provide a summary of what the invention is, you know, maybe what it's used for, that kind of thing. Then there's the application also has some background information, where it's going to talk about the market, where the invention fills unfulfilled needs right now in that market, that kind of thing. Then there's going to be a summary of the invention. Here's an overview of the invention. Here's what it does. Here's maybe how it's kind of the overall design, how it's manufactured, that kind of thing. Then we have a detailed description of the invention. So this would include probably, you know, 3D illustrations, things like that. May talk about, it may not just be the design, but part of it might be the materials it's made out of, the manufacturing processes, the assembly processes, those kind of things that make it unique. And so that's where you really have to look at it in that detailed description. The more detailed, the better it is. The conclusion, you know, where it spotlights, now that you've provided the summary, the market need, that kind of thing. Now the conclusion, spotlighting the advantages of your invention or your improvement and why the market needs that. And then we have the claims, which is the exact description of the aspects of your invention to be protected. So sometimes you may have a design that is something completely new and different, never thought of, type of thing. And so then, you know, you're looking at the protection of the whole design. Now you look at other inventions, because I mean, there's a lot of stuff that the first patent was issued like 228 years ago. So I mean, there's, I don't know, millions of patents out there. And so now all of a sudden, a lot of things now are new improvements to things. So, you know, what are the exact aspects of the invention that you want to protect? So it could be fine-tuning the design, like you said. It could be adding some fundamental element to the design, or a process. How is a process being redefined? You know, it could be, you know, you look at, for example, the Ford stamping plant out in Hamburg a few years ago, when all of a sudden they went to stamping all the aluminum panels for when it was 6-7 years ago, when the Ford F-Series went to aluminum body panels instead of steel. And the Ford Flex, which kind of like their truck station wagon type of thing, same thing, almost exclusively aluminum panels. And so now they were stamping steel panels and stealing a lot and stamping a lot of aluminum panels. Well, part of that was that they had scrap. Obviously, every time you stamp a component, there's stuff on the fringe and everything else. And so now, the price of aluminum and the price of steel is so high that you want to recover all that scrap. So they put this whole system in place that sucks it into overhead vents and everything else. And it has ways of then separating the steel from the aluminum and things like that. So when you look at from a standpoint of the stamping facility and how the lines are automated, kind of like, mass production, the moving assembly line type of thing, that's all established technologies. But maybe there's something now in this scrap recovery system that there might be some elements of that are patentable. So that's why you really have to look at this. Yeah.
Say, John,
Yeah.
but just in the interests of time,
Sure.
and we are really at already a couple of minutes over.
Okay.
Can you finish up on this? And can we go to a couple of questions
Yeah.
before we end
Yeah.
up the
But
session?
it's just what's in front of us. That's the rest of it. So like I said, and then, so we talk about the claims. And then the other thing is when you file a patent application, after 18 months, the Patent and Trademark Office publishes copies of all the patent applications, which isn't necessarily a bad thing because it puts other people on notice of what you filed as a patent. And again, you're already 18 months into the process. So the first file, first awarded type of thing. But you can have the option of the non-publication request type of thing. All right, like I said, submissions typically receive more than 5,000 patent applications annually. Rejection rates, about 86% on average of all applications are initially rejected. They'll send out questions, deficiencies, that type of thing. The applicant will provide that supplemental information. Sometimes it may go through 2 or 3 cycles. And then the overall success rate is about 70%. What that includes, the higher rate that when you're doing like the continued amendments, that kind of thing. Acceptance rate, if you're using a patent attorney, is typically 90% or a little better than 90%. And that again, they know what to look for. The searches, they're kind of like you use a patent attorney, your application is getting pre-screened before it goes to the patent, to the USPTO. Reasons for application: the proposed invention lacks the unique and useful features from similar existing inventions, products, services, whatever. Improperly written or incomplete application, again, that's something you can fix. Errors in the application, again, something that can be fixed. It's more of a timeline type of thing. Cost, filing fees are relatively small. You're talking, in the hundreds of dollars, that kind of thing. Typically, when you're going to look at involving patent attorneys, patent examiners, that kind of thing, in the long run, it may be more cost effective because they know what to look for. They can do all the preliminary searches, all that kind of thing, reduce the probability of rejection. If it's a simple invention, could be $5,000, could be $15,000. What you think is simple could be very complex because you have to look at all the elements of the invention. Just because you've never seen anything like it on the marketplace doesn't mean there isn't already a number of patents issued on that. They just aren't in the market right now, type of thing. Complex inventions, $15,000, it could be $20,000, $30,000, $40,000, depending on the complexity, the amount of review, the in-depth, how in-depth the search needs to be, that kind of thing. It's tough to figure out. Again, what you might be best off is going to a patent attorney. If you've got an idea and you're seriously contemplating that, you might call a firm like Simpson & Simpson, which does patents, locally that say, hey, I've got this idea, can I come in? And they may have a program where, for a couple $100, they'll sit down with you for an hour or two and say, okay, before we can do this is or isn't going to work, or before you go any further, this has potential, but you need to do this, this, and this. And that may be the best starting point before you go overboard on it, that you have, again, the standpoint that you've got back here in the very basics where I talk about you work on your invention, you document the process, maybe you've sketched out some diagrams, that kind of thing. So it gives them some working documents that they can look at and give an honest evaluation based on what's there, what else would need to happen type of thing. Okay, so let's go to any other questions that we have right now.
Okay, well, there is one here. Some of the points that you have already covered. I think you covered photography.
Right.
As far as educational programs, this person is thinking of training that will be offered online. Is there intellectual property protection that can be devised for something like that?
Yeah, I mean, you could have things marked as proprietary information. So let's say you're doing an online course in the course materials kind of thing. You have to look at, I guess what you'd have to define if you're going to put like some kind of online educational course, what are you going to offer? What's included in the services type of thing? So that, for example, if you're teaching teachers and you're providing handouts, then, and there are handouts where they could be student evaluations, student exercises, things like that, it would make sense from a registrant standpoint in the course that if you provided those materials, then they could turn around and use those materials in their classrooms. So, that then you have to look at the contract that you have with the registrants. What services are you providing? And then is there a step 2 where then you also provide a classroom package or something like that? So, I mean, a lot of it, you've got to kind of look at defining what your service is going to be and determine, what you're going to provide to the registrant at what point in time, or is it a multi-step process where one part of it is kind of the educational component to the teacher, and then there's going to be another one where you look at what's there. And again, you have to look at, make sure that the materials that you're developing have you independently developing them and not just kind of put your name on it, and it's something that may be the intellectual property rights maybe with somebody else already.
Okay. All right, thanks for answering that. We've got, how about this one? Can a patent or trademark, which was registered under my organization as a sole proprietorship, can that be transferred? Can the patent or trademark be transferred over to a later established LLC?
You can, yeah, I mean, you can even, I mean, it happens all the time where a company gets bought by another company and the assets get transferred over. So then it's a matter of the original patent is going to be in the name of the sole proprietorship. So then, is that an asset? If you've defined with an LLC, if you've defined that as an asset in the operating agreement and it's on the books as an asset, then it's just a matter of looking at whether or not the registration needs to be updated with the U.S. Patent and Trademark Office. And again, that may be similar to biannual registration for an LLC itself, where it gives you the opportunity to update, who the primary players are, the address for service of process, the various points of contact, that kind of thing.
Okay. Well, we're 10 minutes past our scheduled time. There were a couple of other questions which I would like to submit to you after this. And I'll go ahead and once you provide a response to that, to those questions, I'll include that in a message to our attendees.
Okay.
So if we can do that, I would at this point like to say thank you for the presentation and remind all the attendees that with regard to a link to this presentation, to the recording of this presentation, as well as a PDF of the slides from the presentation and any of the attachments that the additional documents that John has talked about here, the 3 additional things, we'll be sending those out to the attendees. We'll try and get them out by latest tomorrow afternoon, and attendees can be they can be expecting also a copy of responses to the questions that were in the chat. I'm sorry we were not able to go ahead and bring in individuals, allow our attendees to open up their microphones during this presentation. We had almost 60 people who have attended. I would like to thank all of you attendees for having attended. John, I'd like to thank you again for making your presentation and giving us the benefit of your insight and knowledge. Thanks a lot. I'd like to again wish everybody a good evening. Thanks. Look for other webinars from Buffalo Niagara SCORE on our website, buffaloniagara.score.org. And good evening to everyone. Thank you.
Good night.